I'm Evan Middleton, 45 years old, and until recently I was a senior partner at Whitmore & Associates, a prestigious law firm known for its dedication to Fortune 500 clients. I built my career there over the last 22 years, steadily growing a client portfolio valued at approximately $45 million. This wasn't just about numbers. Every client relationship was the product of meticulous attention, trust, and an unwavering commitment to delivery. I never missed a deadline, never let a client down, and always ensured that every legal obligation was met with precision. My role encompassed more than just legal advice. I was the lead for corporate client relations, managing a team of attorneys and support staff who handled complex contracts, negotiations, and dispute resolutions. Over the years, I developed a reputation for reliability and expertise, often consulted by senior management on client retention strategies and risk mitigation. My work ethic was tireless. I routinely worked around the clock to meet the demanding schedules of multinational corporations, ensuring their sensitive transactions were airtight and compliant. But last month, everything changed abruptly. Bradley Carroll, son of our CFO, who was only recently elevated to junior partner status, called me into his office. Without the usual formalities or any prior warning, he informed me that I was being let go. The reasoning was vague, framed as a strategic realignment for the firm's future. What struck me was the cold efficiency in his delivery. Bradley, inexperienced and clearly under his father's influence, was replacing me with his college friend, a junior associate with far less experience and a substantially lower salary. When he told me, I simply said, "Understood." Internally, I didn't react emotionally. Years of experience taught me the value of measured responses in moments of upheaval. Instead of conflict, I began mapping out my next move. I knew this wasn't just about a job loss. It was a deliberate power play driven by nepotism and cost-cutting. But I also understood my strengths, the relationships I had cultivated, the contracts I had negotiated, and the knowledge I possessed about the firm's operations and client database. I left that meeting with a calm mind and a precise plan forming. My first priority was to assess what leverage I had professionally, legally, and contractually. I knew the clients trusted me, not just the firm. They'd come to rely on my guidance, my ability to anticipate legal pitfalls, and my responsiveness. I was also aware of the partnership agreements that governed my equity stake and the protections embedded in client contracts, especially those non-solicitation clauses that would prevent the firm from transferring my clients so easily. This wasn't a moment for rash action or public outbursts. I documented everything: the meeting, the dismissal letter, Bradley's communications. I reviewed my partnership agreement and client files, already anticipating the next steps. There was a larger picture at play. This firing was not just a personnel change, but a fundamental breach of fiduciary responsibility, potentially exposing the firm to significant legal risk. In the weeks that followed, I maintained a professional demeanor, engaging only through official channels and allowing my legal team to prepare. Internally, I was mobilizing resources, identifying allies, and securing my position with the clients who had stood by me for more than 2 decades. I had a reputation to uphold and a portfolio worth protecting. Losing my job that day was a blow, certainly, but it was far from the end. Rather, it marked the start of a calculated and strategic response. I was ready to move forward, not with anger or resentment, but with the kind of professional rigor and patience that had defined my entire career. The next moves would be decisive, structured, and above all, grounded in the detailed documentation and deep relationships I had built over 22 years of dedicated service. My career began back in 2001, fresh out of law school and eager to carve a niche in corporate law. From the outset, I gravitated toward client relationship management because I understood early on that legal expertise alone wasn't enough to build lasting partnerships. It was the combination of legal acumen, trust, and consistent communication that made the difference. As I grew within Whitmore & Associates, I specialized in complex corporate contracts, mergers, acquisitions, regulatory compliance, and large-scale negotiations that often involved multiple stakeholders across jurisdictions. Over 2 decades, I successfully led contract negotiations and renewals worth upwards of $45 million annually, representing some of the most prestigious Fortune 500 companies. Managing these accounts was no small feat. Each client had unique priorities, risk appetites, and regulatory environments. I developed tailored strategies to anticipate potential legal pitfalls and structured contracts to protect their interests without compromising the firm's standards. This required not only sharp legal reasoning, but also strategic foresight and meticulous documentation. I maintained detailed records of every contract clause, every amendment, and every correspondence, understanding that these elements could make or break long-term client trust and legal compliance. A critical part of my role was negotiating and enforcing non-solicitation clauses within client agreements. These clauses were designed to protect both the firm and its clients by preventing abrupt client poaching or unauthorized reassignment. Drafting these provisions required a deep understanding of contract law nuances and the specific business needs of each client. Over time, these clauses became a cornerstone of our client retention strategy and a significant factor in my leverage when disputes arose. Beyond just contracts, I was also responsible for the day-to-day management of a team of 15 attorneys and support staff, a mix of seasoned lawyers and junior associates. My leadership focused on fostering a collaborative environment that balanced rigorous legal standards with efficient client service. I implemented workflow systems that allowed my team to coordinate seamlessly, ensuring deadlines were met and client inquiries addressed promptly. My approach emphasized accountability and precision, with regular internal audits of case files and billing records to maintain transparency and compliance with firm policies. Throughout my tenure, I became a trusted advisor, not only to clients, but also to the firm's senior management. They frequently sought my input on risk mitigation strategies related to client retention and regulatory compliance. I was often invited to present detailed reports on client satisfaction metrics and contract renewal forecasts. My recommendations influenced firm-wide policies on pricing structures, conflict of interest management, and intellectual property protections. Maintaining this level of involvement required constant vigilance and a proactive mindset to navigate shifting legal landscapes and market dynamics. Despite the demanding nature of my work, I consistently upheld a flawless track record, never missing a deadline, never allowing a client's interest to be compromised. This was no accident. I routinely invested long hours, often working well past normal business hours, to review contract drafts, verify compliance checklists, and coordinate with external counsel or regulatory bodies. I understood that for Fortune 500 clients, even a minor oversight could have significant financial or reputational consequences. My dedication earned me a reputation as the go-to partner for intricate corporate matters and crisis management. Financially, my contributions were recognized with a partnership salary of $225,000 annually, supplemented by benefits and an equity stake that had fully vested according to the firm's partnership agreement. The vesting schedule was clearly outlined in my contract, stipulating incremental equity ownership over a defined period, culminating in a substantial payout upon full vesting. This equity was not merely a financial reward, but also an affirmation of my long-term commitment and integral role within the firm's leadership. Yet this level of responsibility and compensation also made me a target. When the CFO's son, Bradley Carroll, recently entered the firm as a junior partner, his mandate, direct or implied, was clear: reduce costs and consolidate control. My salary and vested benefits were seen as expendable expenses, and my extensive client portfolio was viewed as a resource to be reallocated. But what Bradley underestimated was that my value wasn't just in the contracts or my salary line item, it was in the trust, loyalty, and institutional knowledge I had built over more than 2 decades. That foundation was solid, legally binding, and not easily dismantled. In summary, my career at Whitmore & Associates was not just a job, it was a meticulously constructed professional legacy. It rested on precise contract management, strategic client engagement, and rigorous leadership. These factors combined made me indispensable, until the day I wasn't. The groundwork I laid, however, would become the cornerstone of my response to the abrupt and politically motivated dismissal orchestrated by Bradley. The client relationships, contractual leverage, and detailed documentation I maintained were not just assets. They were the tools I would use to protect my career and clients alike. Bradley Carroll was only 30 years old and freshly installed as a junior partner, a position secured largely through his father's influence as CFO of Whitmore and Associates. Unlike me, Bradley lacked the 2 decades of client-facing experience and operational knowledge that underpin successful law firm leadership. His appointment was less about merit and far more about consolidating family control and slashing costs in the firm's overhead. From the outset, his intention was straightforward. Remove me quietly, deny me any of the benefits I had rightfully earned through years of service, and replace me with someone far cheaper, his college friend, an unseasoned junior associate with a fraction of my experience and a salary less than half of mine. Bradley's plan was systematic, but short-sighted. He believed he could execute a clean personnel change without disrupting the client relationships I had spent over 2 decades cultivating. His mindset was that clients belonged to the firm alone, not to individual partners. This was a critical oversight. I knew from countless contract negotiations that many client agreements included strict non-solicitation clauses that protected my role and restricted the firm from unilaterally reassigning clients without consent. These provisions were precisely designed to maintain continuity and protect client interests, but they also created significant legal hurdles for any attempt to simply reallocate my portfolio to an inexperienced replacement. Moreover, Bradley grossly underestimated the operational control I held, specifically over the firm's secure digital client database. This database was not only a repository of sensitive client information and case files, but also a controlled access environment where permissions were granted on a need-to-know basis. I was the custodian of this database, rigorously overseeing who could access what and when. Any unauthorized transfer or duplication of client files without my authorization would constitute a clear violation of data protection protocols and client confidentiality standards. In other words, Bradley's intention to quietly transfer client files to his friend was not only unethical, but also potentially illegal under firm policies and relevant privacy laws. Additionally, Bradley ignored the fiduciary duties owed by the firm's leadership to its clients. These duties require acting in the client's best interests, maintaining confidentiality, and ensuring that any changes to client representation do not compromise service quality or legal standing. His unilateral decision to replace me with someone unqualified and unvetted represented a direct breach of this responsibility. Compounding this, internal compliance audits conducted within the firm had previously flagged risks associated with sudden client reassignment and the need for thorough client consent, a procedure Bradley bypassed entirely. These audit reports, which I had access to, highlighted the firm's vulnerability to regulatory penalties if client transitions were mishandled. Bradley's approach was marked by a disturbing combination of arrogance and inexperience. He seemed to assume that a forced termination and quick client handover could be executed without repercussions. He failed to recognize that my comprehensive knowledge of client contracts, partnership agreements, and firm policies constituted a formidable barrier to his plans. The partnership agreement, for example, clearly stipulated the conditions for equity vesting and payout upon termination. According to this agreement, I was entitled to a $1.8 million equity payout, fully vested after years of service, money Bradley sought to withhold by fabricating baseless performance issues. In sum, Bradley's motivations were deeply rooted in consolidating power and reducing firm expenditures, but his execution was riddled with critical oversights. He aimed to cut costs by hiring an inexperienced friend at a fraction of my compensation, disregarding the legal and professional complexities involved in client reassignment and partnership termination. He underestimated the binding contractual protections I had meticulously negotiated on behalf of my clients and myself, as well as the institutional mechanisms, such as data access controls and fiduciary responsibilities, that would inevitably expose his mismanagement. While Bradley viewed this as a straightforward cost-cutting maneuver, I recognized it as a breach of professional ethics and contractual obligations. It was clear to me that his plan had inherent vulnerabilities that I could strategically leverage. My next steps would hinge on exposing these breaches through documented evidence, enforcing client rights under non-solicitation clauses, and asserting my rightful equity stake. Bradley's underestimation of these factors would prove to be a pivotal miscalculation in what was shaping up to be a protracted and complex professional dispute. Reviewing the termination documents Bradley's office had sent me, I immediately noticed glaring inconsistencies. The formal letter cited vague performance issues as the cause for my dismissal. This was an obvious fabrication. My annual reviews, client feedback, and internal audits all reflected exemplary performance with no negative remarks. I had a spotless record of meeting deadlines, exceeding billable hour targets, and maintaining client satisfaction metrics well above firm averages. The performance issues claim was a clear attempt to manufacture grounds for termination and deny me the equity payout I had fully earned. Digging deeper, I received internal memos and email chains through privileged channels, which revealed that Bradley had already begun moving client files behind my back. These were not casual transfers. They involved unauthorized copying and sharing of sensitive information stored within the firm's secure digital client database, a system I managed personally. The database's access logs showed anomalous activity, file downloads and transfers initiated by Bradley's junior associate friend, who did not have the necessary permissions. This indicated a deliberate breach of firm policy and data protection protocols, violating both internal regulations and professional confidentiality standards required by law. I cross-referenced these unauthorized transfers against the firm's data protection policies. The firm mandated rigorous authorization processes for any client file access or transfer, including digital signatures and supervisory approvals. None of these procedures had been followed. In fact, my audit of recent activity exposed multiple red flags: access granted outside business hours, bypassed security checks, and absence of notification to affected clients. These violations exposed the firm to immediate regulatory risk under data privacy laws, especially considering the sensitive nature of corporate client information involved in ongoing mergers and litigation. Simultaneously, I revisited the partnership agreement in meticulous detail. The agreement clearly spelled out the vesting schedule for equity, incremental ownership, culminating in a full stake after 15 years. Having served over 22 years, I was fully vested, entitled to a payout amounting to $1.8 million. Yet, the termination documents explicitly denied me this payout, citing the manufactured performance issues to justify forfeiture. This was a blatant breach of contract, one that I knew could be contested through legal channels. I documented every clause supporting my claim, highlighting the firm's obligations and the limitations on terminating partners without cause. Alongside the partnership terms, I compiled all client contracts I had managed, focusing on the nearly 52 high-value accounts under my oversight. These contracts contained detailed non-solicitation clauses, legal provisions preventing the firm from reassigning or soliciting clients away from a departing partner without explicit written consent. These clauses were negotiated carefully over years to protect both client interests and the stability of client-partner relationships. I knew these protections would be central to my leverage against Bradley's attempts to transfer clients to his inexperienced friend. I also reviewed communication records, emails, meeting minutes, and client acknowledgements that demonstrated the client's established rapport and reliance on my counsel. Many clients had explicitly indicated their preference for my continued representation in writing. These documents would prove invaluable in demonstrating that unilateral reassignment violated contractual obligations and fiduciary duties owed to clients. By the end of this comprehensive assessment, I had identified 3 critical leverage points. First, the falsified termination reasons violating the partnership agreement. Second, the unauthorized client file transfers breaching data protection policies. And third, the non-solicitation clauses embedded in client contracts that restricted client reallocation without consent. Additionally, Bradley's disregard for fiduciary duties, namely acting in the best interests of clients and maintaining confidentiality, compounded the firm's legal exposure. I assembled these findings into a detailed dossier, organizing evidence chronologically, with cross-references to contractual provisions and regulatory compliance standards. This methodical approach was essential to prepare for potential legal challenges and negotiations. The data showed a clear pattern of misconduct and breach of professional obligations by Bradley and the firm's management. Throughout this process, I remained composed and strategic. The stakes were high, but my extensive documentation and measured analysis gave me confidence. I understood that exposing these violations would not only protect my vested equity, but also preserve client trust and prevent operational disruptions. Bradley had underestimated the structural safeguards I had put in place and the professional rigor I would bring to bear. With this foundational assessment complete, I was poised to move forward, engaging legal counsel, notifying clients discreetly, and preparing to enforce the contractual protections that Bradley's reckless actions had jeopardized. The path ahead required patience and precision, but I was ready. After completing my thorough review of all pertinent documents and identifying the key breaches, I knew the next step had to be legally precise and strategically sound. I needed expert counsel, familiar with the intricacies of partnership disputes and employment law at law firms. That's when I engaged Marcus Reed, an employment lawyer with a solid track record in handling complex disputes involving senior partners and equity claims. Marcus brought a sharp analytical mind and practical courtroom experience, exactly the kind of legal ally I needed to navigate the multifaceted challenges ahead. Our initial meetings focused on organizing the mountain of documentation I had assembled. Marcus emphasized the importance of a meticulous chronological record to clearly demonstrate the timeline of events, breaches, and unauthorized actions. Together, we developed a detailed indexing system. Every email chain, contract version, termination notice, internal memo, and data access log was cataloged and cross-referenced. This system was essential not only for legal filings, but also to maintain control and clarity throughout what promised to be a protracted dispute. We started by cataloging the 52 high-value client contracts I managed. Each contract was reviewed line by line to highlight the non-solicitation clauses and relevant provisions protecting client-partner relationships and restricting the firm's unilateral reassignments. Marcus noted how these clauses were unusually robust, reflecting the firm's prior efforts to secure client loyalty and prevent client poaching. This contractual language gave us a significant legal foothold to challenge any attempts by the firm, or Bradley specifically, to transfer or solicit clients without explicit consent. Simultaneously, we compiled a comprehensive audit trail of all communications related to my termination and subsequent client file transfers. This included emails between Bradley, his junior associate replacement, and various administrative staff that indicated unauthorized access or attempts to circumvent data security protocols. Marcus pointed out that these unauthorized accesses strongly suggested deliberate misconduct, potentially violating not only internal policies, but also applicable data protection laws such as the GDPR and CCPA, given the multinational nature of many clients involved. To reinforce our position, we gathered billing records and client correspondence, demonstrating the continuity and depth of my relationship with each key client. These records showed not only the financial stakes, but also the expressed client preferences for my direct involvement, a critical factor in establishing the potential harm caused by the firm's abrupt reassignment plans. Marcus stressed that these client testimonials and written confirmations would be invaluable in both settlement negotiations and regulatory complaints. Recognizing the need to corroborate these findings, I discreetly reached out to trusted former colleagues and senior staff who had witnessed Bradley's mismanagement and the improper file transfers. Their statements were carefully documented under confidentiality agreements, providing additional witness accounts of the firm's internal policy breaches and the questionable circumstances surrounding my termination. Marcus advised me to maintain strict professionalism in all communications, ensuring that nothing could be construed as defamatory or unprofessional, which could otherwise weaken our case. In parallel, Marcus and I reviewed the firm's partnership agreement in exhaustive detail. We identified clear violations: the firm's wrongful termination without just cause, improper denial of my fully vested equity payout of $1.8 million, and breaches of fiduciary duty owed to me as a senior partner. Marcus prepared a legal memorandum outlining these contractual breaches and the potential remedies available under both state partnership law and firm-specific regulations. This memo would form the backbone of any legal actions we pursued. Understanding the firm's internal compliance audits that had flagged risks of sudden client reassignments, Marcus saw an opportunity to include these findings in regulatory complaints. We prepared preliminary drafts of formal grievances to be submitted to the State Bar Association, highlighting ethical breaches by Bradley and the firm's leadership, particularly concerning client fiduciary responsibilities and data confidentiality violations. This regulatory pressure aimed to compound the legal challenges facing the firm and increase leverage in negotiations. Behind the scenes, I arranged secure backups of all client communications and digital records under my control, ensuring the integrity and availability of critical evidence. Marcus underscored the importance of maintaining chain of custody logs and detailed metadata reports to authenticate these records. We established encrypted channels for all correspondence and document exchanges to prevent any unauthorized interception or destruction of evidence. Throughout this phase, my internal strategy was clear: to build an airtight, legally defensible case resting on well-documented contractual violations, client loyalty, and fiduciary duty breaches. I was preparing not just to defend my vested rights, but to demonstrate the firm's systemic failures and ethical lapses. Every step was methodical, every document scrutinized, every communication vetted for maximum evidentiary value. The foundation was set, with Marcus's expertise guiding the legal and professional framework and my exhaustive documentation providing the factual backbone. We were poised to escalate from assessment to action. The groundwork we laid was critical. It transformed a sudden professional setback into a carefully orchestrated campaign to uphold my rights, protect client interests, and hold the firm accountable for its breaches. What remained was to translate these preparations into concrete legal motions and client outreach. But before taking those steps, it was essential to secure the integrity of our evidence, confirm the strength of our legal arguments, and ensure that every move was strategically calibrated. The next phase would be one of activation, where legal strategy intersected with client relations to begin reversing the damage Bradley's decisions threatened to inflict. After engaging Marcus Reed, an employment lawyer well-versed in partnership disputes and corporate law, our focus immediately turned to constructing a comprehensive legal case built on the foundation of the documents and evidence I had compiled. Marcus dove deep into the firm's partnership agreements, client contracts, and internal policies, scrutinizing every clause and provision for possible breaches and legal violations. The first glaring issue Marcus identified was the wrongful termination itself. The partnership agreement explicitly required just cause for dismissal to withhold a fully vested equity payout like mine. Bradley's fabricated performance issues claim was not only unsupported by any documented performance evaluations, but also contravened the firm's own disciplinary procedures. Marcus explained that wrongful termination in this context was a serious breach of contract that could trigger significant damages, including the full release of my $1.8 million equity stake, plus compensation for lost income and reputational harm. Further, Marcus highlighted breaches of fiduciary duty on multiple fronts. The partnership agreement and applicable corporate governance codes mandated that firm leadership act in the best interests of clients and partners alike, preserving confidentiality and ensuring continuity of legal services. Bradley's unilateral decision to terminate me and transfer my client portfolio to his inexperienced friend violated these duties. It failed to consider client consent, service quality, or operational risks. Marcus pointed out that fiduciary breaches could expose the firm to regulatory penalties and bar complaints, especially since client interests were directly compromised. A critical element Marcus focused on was the unauthorized reassignment of client accounts. Nearly all 52 high-value client contracts contained stringent non-solicitation clauses explicitly prohibiting the firm from reassigning clients without written consent from both the client and the departing partner. Marcus reviewed these clauses line by line, confirming their enforceability under state contract law and their potential as a legal bulwark against Bradley's scheme. The language was clear. Any attempt to circumvent these provisions would constitute a breach of contract with grounds for injunctive relief and damages. The technical evidence we amassed further strengthened our position. Access logs from the firm's secure digital client database documented unauthorized downloads and file transfers initiated by Bradley's junior associate replacement. Marcus explained that these acts were not mere administrative oversights, but could amount to violations of data protection laws like the GDPR and CCPA, depending on the client's jurisdiction, as well as breaches of professional confidentiality obligations under the state bar's ethical standards. This exposed the firm to potential regulatory investigations beyond civil litigation. Marcus also underscored the significance of the email correspondence from clients expressing dissatisfaction with the firm's abrupt personnel changes and their clear preference for my continued representation. These communications were essential to demonstrate actual harm, both reputational and financial, that the firm's actions had caused. Additionally, billing records showed that these clients contributed substantial annual revenue, underscoring the material impact of any forced transfer. Recognizing the potential challenges in court, Marcus advised building a multi-layered case combining contract law, fiduciary duty claims, employment law, and regulatory ethics violations. We prepared preliminary drafts of legal motions to assert my right to the equity payout, demand cessation of unauthorized client solicitation, and seek damages for wrongful termination and associated losses. Marcus also initiated drafting a formal complaint to the State Bar Association, detailing ethical breaches by Bradley and the firm's management, particularly relating to client confidentiality and fiduciary obligations. To reinforce our case, I coordinated confidential witness statements from trusted colleagues who had observed Bradley's mishandling of client transitions and breaches of protocol. These depositions were carefully documented and vetted to ensure they adhered to legal standards and preserved professionalism. Marcus stressed the importance of maintaining an airtight evidentiary chain to withstand scrutiny during discovery and potential trial. Simultaneously, we implemented rigorous evidence preservation protocols. Marcus advised securing encrypted backups of all client files, correspondence, and data access logs under my control, ensuring metadata integrity and chain of custody. We established secure communication channels for all legal correspondence to prevent unauthorized leaks or interference. This procedural discipline was critical to preserving the weight and admissibility of our evidence. Throughout this phase, my approach remained calculated and measured. Every document was cross-referenced, every communication carefully worded. Marcus's legal expertise complemented my deep operational knowledge, enabling us to craft a case that was both technically sound and strategically compelling. The goal was not merely to contest my termination, but to expose systemic failures in governance and client management that Bradley's actions revealed. This detailed legal groundwork was essential before initiating any public client outreach or formal legal actions. We needed to be certain that our claims were substantiated beyond dispute and that the firm's breaches could not be easily dismissed or ignored. The evidence we compiled would form the basis for regulatory complaints, client notifications, and courtroom filings. With a meticulously constructed legal dossier in hand and a clear roadmap for the next steps, Marcus and I were ready to transition from case building to enforcement. The foundation was solid: wrongful termination without cause, breach of fiduciary duties, unauthorized client reassignments violating contractual non-solicitation clauses, and data confidentiality breaches creating regulatory liability. Each element reinforced the others, collectively strengthening our position. The next phase would require a delicate balance, assertive enough to protect my rights and clients' interests, yet professional and strategic to avoid unnecessary escalation or reputational damage. We had identified the firm's vulnerabilities and were prepared to leverage every legal and contractual tool available. From this point forward, every move would be calculated to maximize pressure while preserving the integrity of my professional standing. This was not about personal vindication alone. It was a professional imperative to uphold legal and ethical standards in a complex environment where nepotism had compromised sound governance. Our legal strategy embodied that imperative, grounded in detailed analysis, robust evidence, and thorough documentation, hallmarks of the career I had built and the approach I intended to carry forward. With the legal groundwork firmly in place and our initial filings submitted, I shifted focus to the critical task of client engagement. I knew that the 52 key clients, whose contracts contained robust non-solicitation clauses and who had placed their trust in me over 2 decades, were the cornerstone of this entire effort. Discreet communication was paramount. Any premature or overt outreach risked provoking countermeasures from the firm, potentially jeopardizing ongoing negotiations and regulatory complaints. I carefully drafted personalized letters for each client, meticulously referencing their specific contractual rights and the firm's obligations under those agreements. The tone was professional and reassuring, emphasizing continuity of counsel and my unwavering commitment to their best interests, despite the internal upheaval at Whitmore & Associates. These communications highlighted the binding nature of the non-solicitation clauses and gently reminded clients that any forced reassignment without their explicit consent could be contested. I included direct contact information for myself and Marcus Reed, my legal counsel, to facilitate any questions or requests for clarification. Simultaneously, I set about establishing a new operational base. Recognizing the urgency of uninterrupted service, I secured a professional office space in a location convenient to key clients and easily accessible to my team. Equally important was building an IT infrastructure that could support the sophisticated legal work and secure data management my practice demanded. I engaged a trusted IT firm specializing in legal cybersecurity to replicate and enhance the data control systems I had previously managed, ensuring encrypted client communications, robust access controls, and real-time audit logs. This infrastructure was designed not only to meet but exceed industry standards, signaling to clients and regulators alike that their data security and confidentiality remained paramount. To staff this new practice, I reached out to select colleagues and former associates with proven expertise and loyalty. These individuals were briefed on the sensitive nature of the transition and the importance of confidentiality. Together, we developed protocols for client onboarding, document handling, and billing processes that mirrored the high standards clients expected from Whitmore & Associates. Establishing these operational norms early was critical to prevent service disruptions that Bradley's team might count on to undermine client confidence. Throughout this phase, I maintained strict professional boundaries with Whitmore & Associates. All external communication regarding the dispute was routed through Marcus's office to avoid missteps or inadvertent disclosures. Internally, I documented every contact and correspondence meticulously, ensuring a transparent record for potential regulatory scrutiny or litigation. This approach minimized risk and projected an image of measured professionalism, reinforcing my credibility both with clients and industry observers. Bradley, meanwhile, remained unaware, or at least underestimated, the scope and precision of my preparations. Reports from trusted internal sources indicated he was preoccupied with integrating his junior associate friend and celebrating the apparent short-term cost savings. This complacency only strengthened my resolve to proceed with calculated patience. I anticipated that his overconfidence would increasingly expose the firm's operational vulnerabilities and regulatory non-compliance, which my legal filings and client communications were already beginning to highlight. The strategic positioning was clear. By simultaneously asserting legal rights through formal notices and ensuring seamless client service continuity, I was creating a dual front of pressure. Clients would feel secure in transitioning their accounts, while the firm faced mounting contractual and ethical challenges. The new office and IT foundation were not merely symbolic, but instrumental infrastructure, supporting this coordinated client exodus. I also prioritized reinforcing client confidence by scheduling confidential one-on-one meetings, mostly virtual due to geographic dispersion, with decision-makers at each key account. These discussions focused on understanding their concerns, outlining how the new practice would maintain or enhance service levels, and addressing any contractual questions. Feedback from these meetings was documented and fed back into our legal strategy, strengthening our position by demonstrating active client consent and engagement. This phase demanded vigilance. I regularly reviewed billing continuity reports and client communications to detect any signs of interference or attempts by the firm to disrupt the migration. Marcus advised maintaining a low public profile to avoid escalating tensions unnecessarily, while preparing for potential pushback through formal channels. In essence, the trap was set with strategic precision. Legal notices enforcing contractual protections had been served. Clients were fully informed and reassured. A robust independent practice infrastructure was operational, and my team was aligned and ready to execute the transition flawlessly. Bradley's miscalculated gamble was unfolding exactly as predicted, but the battle was far from over. The ensuing weeks would test the strength of these preparations as client defections and regulatory actions began to ripple through the firm's fragile facade. Within 2 weeks of initiating my client communications and legal actions, the first tangible signs of disruption began to surface. Almost immediately, I started receiving calls and emails from multiple clients expressing unease about the recent changes at Whitmore and Associates. Their concerns were not merely about the personnel shuffle. They were fundamentally about service continuity, risk exposure, and the integrity of their legal representation. I made it a priority to respond swiftly and professionally to every inquiry, providing detailed explanations of the contractual protections in place and reassuring clients that my commitment to their cases remained unwavering despite the firm's internal turmoil. Each communication was carefully documented, every call logged, every email archived with timestamps and metadata. I knew that in a dispute of this nature, consistency and traceability could become crucial. If the firm contested client movements or alleged improper solicitation. Rather than making any public declarations or broad statements, I maintained a client-specific approach, tailoring responses to address individual concerns, while reinforcing the legal framework supporting their right to choose representation aligned with their best interests. In parallel, we began renegotiating contracts with clients who wished to transfer their legal representation to my newly established practice. This process required meticulous attention to the non-solicitation clauses embedded in their original agreements with Whitmore and Associates. Although these provisions were designed to prevent abrupt client poaching, they also contained exceptions, allowing client choice and consent in cases involving partner departure or wrongful termination, a nuance I emphasized during negotiations. Marcus and I prepared standardized amendment templates and consent forms to streamline transitions, ensuring all contractual modifications were legally binding and fully compliant. The financial magnitude of these transfers was significant. Collectively, these 52 clients represented approximately $32 million in annual billings. We prioritized securing formal written consents to avoid any ambiguity that the firm might exploit. These documents were systematically logged, signed, and stored in encrypted databases with detailed access controls. This rigorous record-keeping was integral to demonstrating voluntary client movement grounded in contractual rights, rather than aggressive solicitation. Meanwhile, operational challenges within Whitmore and Associates began manifesting more visibly. The firm's internal IT system, particularly the secure digital client database which I had administered, started exhibiting access anomalies. Key credentials and permissions required to manage active client files were either missing or revoked without proper handover protocols. This led to delays in document retrieval, case updates, and litigation support for several high-profile matters. I monitored these system disruptions through reports from trusted contacts still within the firm and through public court filings where applicable. The firm's inability to maintain seamless data access underscored the risks Bradley's management approach introduced. Clients relying on timely legal advice and document preparation were directly affected, heightening their inclination to formalize transitions to my practice. I maintained detailed logs correlating these operational failures with client feedback to strengthen our legal arguments concerning breach of fiduciary duty and professional negligence. Simultaneously, regulatory bodies acknowledged receipt of our formal complaints and began preliminary inquiries. Although these investigations moved at a methodical pace, the notification to the firm's compliance department marked a critical inflection point. I ensured that all correspondence with regulators was meticulously archived, preserving the integrity of our case and signaling the seriousness of the ethical violations alleged. Throughout this period, Bradley's behavior grew increasingly erratic, but remained professionally guarded. He made several calls seeking assistance in rectifying client service issues and IT breakdowns, often routed through intermediaries. Each time I responded with measured professionalism, referring all inquiries to my legal counsel to avoid direct engagement and potential miscommunication. This stance preserved my position and prevented inadvertent concessions or admissions. The mounting client defections and operational failures visibly eroded Bradley's confidence within the firm. Internal reports indicated growing dissatisfaction among his management peers and rising shareholder concerns about revenue declines. Despite this, he persisted in defending the initial decision to terminate me and install his friend, seemingly unaware or unwilling to acknowledge the scale of the unfolding crisis. By the end of the 2-week mark, the cumulative effects of our strategic actions had created tangible pressure points. Clients were exercising their contractual rights with increasing assertiveness. Operational disruptions compromised the firm's service delivery, and regulatory scrutiny loomed on the horizon. My legal team and I remained fully engaged, continuously monitoring developments and adjusting our approach to capitalize on every leverage point. This phase was critical. It transformed latent contractual and fiduciary breaches into active challenges confronting the firm's operational viability. Yet the situation remained precarious. The firm could still counter with aggressive legal tactics or escalate internal maneuvers to regain control. Maintaining professional composure, detailed documentation, and client confidence was imperative as we prepared for the next phase, triggering formal legal proceedings and further client transitions. When we finally filed the lawsuit, it marked a pivotal escalation in what had been, until then, a carefully controlled and strategic response. The suit was comprehensive, meticulously detailing the wrongful termination, breaches of fiduciary duty, and violations of the non-solicitation clauses embedded in the client contracts. Each allegation was supported by extensive documentation, termination letters with fabricated reasons, email correspondences highlighting unauthorized client file transfers, internal access logs showing improper data handling, and the partnership agreement spelling out my fully vested equity stake. Our legal complaint didn't just state the facts, it laid out a timeline and a pattern of misconduct that was impossible to ignore. The wrongful termination claim was straightforward, but powerful. The partnership agreement clearly required just cause for dismissal to deny a partner's vested equity payout. Bradley's claim of performance issues was not only baseless, but contradicted by annual performance reviews, client satisfaction surveys, and internal memos praising my leadership. Marcus Reed, my employment lawyer, crafted this section of the complaint to emphasize that the termination was a pretext designed solely to strip me of my $1.8 million equity payout. We included sworn affidavits from colleagues who confirmed the absence of any performance concerns, reinforcing that the firing was motivated by nepotistic cost-cutting rather than legitimate business reasons. On the fiduciary duty front, the suit carefully articulated how Bradley's unilateral decisions endangered client interests and breached obligations owed both to the clients and to me as a partner. The firm had a duty to ensure continuity, confidentiality, and quality in legal representation. Instead, Bradley's reckless replacement of an experienced partner with an unqualified individual without client consent or proper transition planning constituted a violation of these duties. The complaint detailed how these actions jeopardized ongoing litigation and transactional matters, potentially exposing clients to risk. We referenced internal compliance reports that warned of these very dangers, further undermining the firm's defense. One of the most critical legal arguments centered on the violation of non-solicitation clauses. The contracts I had negotiated with 52 high-value clients explicitly prohibited the firm from reassigning their accounts without both client and departing partner consent. Bradley's attempts to transfer these clients to his junior associate friend ignored these contractual obligations. Our complaint included copies of these clauses alongside email evidence showing client pushback against forced reassignment. In many instances, clients had expressed a clear preference to maintain their relationship with me, further validating the enforceability of these provisions. Marcus emphasized that these were not just technicalities, but fundamental protections designed to preserve client autonomy and trust. Simultaneously, we submitted formal complaints to the State Bar Association, documenting ethical breaches by Bradley and the firm's leadership. These complaints focused on violations of client confidentiality due to unauthorized data transfers and breaches of fiduciary responsibility. The regulatory authorities acknowledged receipt and initiated preliminary inquiries into the firm's conduct. This regulatory pressure complemented our civil lawsuit, increasing the stakes and signaling serious professional consequences for misconduct. Marcus advised that coupling civil litigation with bar complaints often strengthens negotiating positions by exposing firms to reputational and disciplinary risks. As the lawsuit progressed, the practical effects began to ripple through the firm. Clients, armed with clear knowledge of their contractual rights and reassured by our communications, increasingly formalized their decisions to terminate contracts with Whitmore and Associates and transfer representation to my new practice. These were not impulsive defections, but carefully coordinated transitions supported by amended agreements and documented client consents. The financial impact was immediate and severe. The firm lost control over roughly $32 million in annual billings, a significant portion of its revenue base. Marcus and I maintained exhaustive logs of these transfers to preclude any counterclaims of improper solicitation or breach of contract. The firm's internal operational infrastructure suffered as well. The secure digital database, to which I had exclusive administrative access, became a bottleneck when key credentials were withheld or revoked improperly. This led to delays in file retrieval, case updates, and court filings on active matters, further fueling client dissatisfaction and accelerating departures. Reports from inside the firm described escalating confusion and frustration among management and staff, exacerbated by Bradley's inability to manage the crisis effectively. Bradley's attempts to mitigate the damage were visibly frantic but ineffective. He made multiple overtures to negotiate settlements and reverse client defections, but I remained resolute. All communication was channeled through Marcus, ensuring a consistent legal stance and preventing any informal compromises. This disciplined approach reinforced my position and avoided giving Bradley leverage through direct dialogue or emotional concessions. Each failed negotiation further eroded his credibility within the firm and the wider legal community. As client defections mounted and regulatory scrutiny intensified, the firm's reputation began to crumble. Industry observers took note of the disruption, and whispers of mismanagement circulated in professional circles. The lawsuit's detailed allegations and supporting evidence left little room for the firm's leadership to dismiss or downplay the severity of the breaches. Bradley's professional standing became increasingly precarious as word of the ethics investigation spread. Despite this mounting pressure, the firm continued to resist fully acknowledging the contractual and ethical breaches at the core of the dispute. The legal process was only in its early stages, and the firm sought to defend its actions as business decisions made in good faith. This resistance meant the battle was far from over. My legal team and I had to remain vigilant, responding to motions, conducting depositions, and preparing for potential trial. The intricate web of contracts, client loyalties, and fiduciary responsibilities demanded careful navigation to safeguard my interests and those of my clients. In this phase, the comprehensive and systematic preparation we had undertaken became crucial. The dossier of evidence, carefully documented client communications, and robust legal arguments created a foundation that could withstand scrutiny and counterattack. The lawsuit was not just a reactive measure. It was a proactive tool to enforce rights, compel compliance, and hold the firm accountable for its breaches. At the close of this stage, the situation remained fluid and high stakes. The firm's financial health was deteriorating as client departures continued, regulatory investigations loomed larger, and internal confidence in leadership faltered. Meanwhile, my new practice gained momentum as clients transitioned and new opportunities arose. The legal contest had advanced beyond a personnel dispute into a complex battle over governance, ethics, and professional integrity within one of the city's most prominent law firms. The outcome would hinge on the strength of the evidence, the enforcement of contractual protections, and the unwavering resolve to uphold established legal and ethical standards. The fallout within Whitmore and Associates accelerated rapidly. The firm's financial statements for the quarter, which I obtained through a trusted contact in the accounting department, showed a staggering decline in revenue. Client departures accounted for nearly 70% of their previous income stream. This wasn't just a minor setback or a temporary dip. It was a near collapse brought on by the systematic exodus of clients who had placed their trust in me and were unwilling to settle for the inexperienced replacement Bradley had installed. The $32 million in annual billings that shifted to my new practice left the firm scrambling to fill a void that no quick hires or internal reshuffling could bridge. Bradley Carroll's tenure in management ended abruptly. Internal communications revealed a boardroom meeting where senior partners, shareholders, and the firm's legal counsel confronted the undeniable impacts of his decisions. His removal from management was framed as a necessary step to stem ongoing losses and restore confidence among clients and staff. The official statement cited strategic realignment following operational setbacks, but behind closed doors, it was clear that Bradley's mismanagement and failure to uphold fiduciary responsibilities were central to the firm's crisis. This ousting was a significant professional blow, not just a loss of position, but a lasting stain on his reputation within the legal community. The firm's license renewal, a routine but critical administrative process, became jeopardized due to the mounting regulatory scrutiny triggered by the complaints we filed. State bar investigators issued preliminary findings that highlighted fiduciary breaches and lapses in client confidentiality directly linked to Bradley's actions. The firm faced potential sanctions and was forced to engage external compliance consultants to conduct emergency audits and implement corrective measures. This level of regulatory attention was rare for a firm of Whitmore's stature and sent shockwaves through its management ranks. Further compounding the firm's troubles, several employees stepped forward confidentially to report additional concerns. These included mismanagement, disregard for internal controls, and a culture of nepotism that had eroded professional standards. Human Resources initiated internal investigations to address these claims, but the damage to the firm's morale and external image was already significant. Staff departures increased as well, with experienced attorneys seeking more stable environments, further destabilizing client service continuity. Media coverage soon followed. Legal industry publications and local business journals picked up the story, framing it as a cautionary tale of nepotism overriding meritocracy. Headlines highlighted the firm's dramatic financial losses, the ethical breaches alleged in regulatory complaints, and Bradley's fall from grace. This public exposure magnified the firm's reputational damage and added pressure from shareholders demanding accountability and swift remediation. Bradley's father, the CFO, resigned amidst the turmoil. Under intense shareholder pressure, he stepped down to facilitate a leadership overhaul aimed at repairing client trust and stabilizing operations. His departure underscored how deeply the crisis affected the firm's executive leadership and financial governance. Shareholders made it clear that nepotistic influence had cost the firm dearly, and rebuilding credibility would require fundamental cultural and procedural reforms. Legal proceedings continued to pile on. Judgments began to favor my claims, with courts recognizing the wrongful termination and breaches of fiduciary duty substantiated by our documentation. Monetary damages awarded totaled over $2.3 million, including the full payout of my vested equity, plus interest and compensation for lost income and reputational harm. These judgments not only imposed financial burdens, but also further strained the firm's liquidity and creditworthiness, heightening insolvency risks. Throughout this period, I maintained a professional posture, allowing the legal process to unfold while focusing on expanding my new practice. The firm's cascading failures validated the strategy I had employed, meticulously documented, legally grounded, and client-focused. The once formidable empire of Whitmore and Associates was unraveling piece by piece, a stark illustration of how neglecting fiduciary duties and client relationships can precipitate rapid decline. However, while these consequences were severe, the situation remained dynamic. The firm was actively engaging restructuring consultants and exploring asset sales to manage liabilities. The legal battle was far from concluded, and the industry was watching closely. My focus remained on preserving client trust, navigating the complex litigation ahead, and reinforcing the professional standards that had always guided my career. The unfolding events would continue to test the resilience of all parties involved, with no room for complacency or premature assumptions. The legal victories we achieved marked a significant turning point in this protracted dispute, yet they represented just one phase in a much larger, evolving professional battle. The court rulings unequivocally enforced my entitlement to the full $1.8 million vested equity payout as stipulated in the partnership agreement. This was not a mere symbolic gesture. It was an acknowledgement of the contractual safeguards I had painstakingly negotiated and upheld throughout my tenure. The judgment underscored the court's recognition that Bradley's fabricated performance issues were baseless and that the firm's attempt to withhold my vested ownership was unlawful. Alongside this, the court awarded an additional $500,000 in damages to compensate for lost income opportunities and reputational harm, an acknowledgement of the tangible financial and professional setbacks imposed by the wrongful termination and ensuing client disruption. These rulings were the culmination of months of meticulous legal argumentation, supported by an exhaustive dossier of documentary evidence, partnership contracts, client agreements, documented communications with the firm, and witness affidavits from colleagues who substantiated the absence of performance issues and confirmed Bradley's mismanagement. The findings validated every element of our claims, from breaches of fiduciary duty to violations of contractual non-solicitation clauses. This legal precedent sent a clear message within our professional community. Contractual protections and ethical obligations in partnership disputes cannot be casually disregarded, even under internal pressures like nepotistic influence. Parallel to the civil litigation, regulatory authorities imposed substantial fines on Whitmore and Associates. The State Bar Association's investigation, triggered by our formal complaints, identified multiple breaches of professional ethics and fiduciary responsibilities. These included unauthorized client file transfers violating confidentiality, failure to maintain adequate safeguards over sensitive client data, and improper reassignment of client portfolios without obtaining requisite consents. The regulatory fines levied against the firm exceeded $1 million, a financial penalty that reflected both the seriousness of these violations and the State Bar's intent to deter similar misconduct industry-wide. More consequentially, Bradley Carroll himself was disbarred, a professional sanction that severely curtailed his legal career and underscored the gravity of ethical breaches in the legal profession. Client retention during this turbulent period was pivotal. As the legal and regulatory processes unfolded, a decisive majority of the 52 high-value clients formally transferred their business to my new independent practice. This migration was executed with careful adherence to contractual protocols and documented consents, ensuring no accusations of improper solicitation could be sustained. These clients collectively represented annual billings of approximately $32 million, effectively bolstering the financial foundation of my new firm and simultaneously stripping Whitmore and Associates of its core revenue base. The client exodus was both a practical and symbolic repudiation of Bradley's mismanagement and the firm's ethical failures. The impact of this case resonated well beyond our immediate circle. It became a frequently cited precedent in legal journals and professional seminars discussing fiduciary duty and partnership disputes. The clarity with which contract enforcement, ethical obligations, and client protections were articulated in the rulings influenced law firm governance policies nationwide. Firms began revisiting their internal controls and partnership agreements, particularly focusing on safeguards against nepotistic appointments and the enforcement of non-solicitation clauses. The case reinforced the necessity for transparent, merit-based leadership and rigorous adherence to fiduciary duties to preserve both client trust and firm viability. My professional standing was also profoundly affected. Rather than being marginalized by the conflict, I emerged as a model of strategic professionalism and principled leadership. The successful navigation of this complex dispute, grounded in detailed contractual knowledge, measured legal strategy, and unwavering client focus, enhanced my reputation in the legal community. Colleagues and clients alike recognized the importance of thorough documentation, contractual literacy, and disciplined patience in safeguarding professional rights. Invitations to speak at industry conferences and contribute to legal publications followed, affirming my role as an authoritative voice on partnership governance and ethical practice. However, despite these substantial legal victories and the shift in industry perspectives, the situation remained a dynamic professional challenge. The firm was still engaged in restructuring efforts, grappling with reputational repair and operational reorganization. The regulatory fines and disbarment did not erase the ongoing financial and managerial turmoil. Meanwhile, my new practice was expanding rapidly, requiring continued attention to client service excellence, compliance, and growth strategies. The legal judgments served as a foundation, but also a catalyst for sustained professional diligence. Throughout this phase, I remained committed to the core principles that had guided my career: integrity, precision, and client advocacy. The case illustrated how contractual safeguards and fiduciary responsibilities, when rigorously documented and enforced, could serve as powerful tools against internal mismanagement and nepotism. It also reinforced the critical importance of maintaining a professional demeanor and strategic patience in navigating conflict, qualities that differentiated me in both legal acumen and leadership. While the firm's collapse and Bradley's downfall were consequential, they were part of a broader narrative about accountability and professional ethics in the legal industry. The case's ramifications prompted ongoing dialogue about governance reforms and the essential balance between family influence and meritocracy in law firm leadership. As I continued to grow my independent practice and serve my clients, these lessons remained at the forefront, shaping not only my approach, but also contributing to a more conscientious legal community. Today, my independent practice manages over $60 million in client billings annually, more than a 30% growth from the portfolio I built over 2 decades at Whitmore & Associates. This expansion reflects not only the volume of business, but also the depth of trust I've maintained with clients who followed me through what was undeniably a turbulent transition. The increase in revenue translated into a 40% salary boost compared to my previous compensation, alongside full equity ownership in the firm, a direct reward for the professional tenacity and strategic foresight I applied throughout this ordeal. Having complete equity ownership has afforded me a level of autonomy that was impossible within the rigid hierarchy and opaque governance of my former firm. I now make all operational and strategic decisions unilaterally, allowing me to align business practices fully with client interests and my team's professional standards. I've instituted rigorous governance protocols, ensuring transparency and accountability at every level. This contrasts sharply with the nepotism-driven mismanagement I witnessed and endured, where decisions were often short-sighted and politically motivated rather than grounded in sound legal and business principles. Operationally, I've invested heavily in building an advanced IT infrastructure that secures client data and streamlines case management. Drawing from my experience as the custodian of Whitmore's digital client database, I understood the critical importance of data integrity and confidentiality. Our systems incorporate end-to-end encryption, multi-factor authentication, and real-time audit trails, not only meeting but exceeding regulatory standards such as GDPR and CCPA. This technological backbone reassures clients that their sensitive information is handled with the utmost care and professionalism. Client relations remain the cornerstone of the practice. I maintain direct personalized communication channels, ensuring that each client receives bespoke legal strategies tailored to their unique corporate frameworks and risk profiles. Unlike the previous firm's impersonal handoffs, I lead a dedicated team of highly skilled attorneys and support staff who embody the same ethos of accountability and precision that I champion. Regular internal audits of case files and billing records uphold transparency, minimizing errors, and reinforcing client confidence. Reflecting on these developments, I recognize that the pivotal factors in reclaiming and surpassing my prior standing were rigorous documentation, contractual literacy, and measured patience. The detailed client contracts with enforceable non-solicitation clauses and the partnership agreements that specified my equity rights were crucial instruments. By methodically leveraging these legal frameworks, I safeguarded client interests and secured just compensation without resorting to emotional confrontations or public spectacle. This disciplined professionalism preserved my reputation through every phase. Moreover, the legal strategy extended beyond personal vindication. It highlighted systemic issues within the law firm's governance, prompting industry-wide discussions on fiduciary duties and partnership ethics. Invitations to speak at professional conferences and contribute to legal journals have allowed me to share insights on navigating complex disputes involving client loyalty, contractual enforcement, and governance reform. These engagements affirm that strategic professionalism, combined with unwavering commitment to ethical standards, can serve as a blueprint for others facing similar challenges. The ordeal reaffirmed the necessity of maintaining composure under pressure and approaching disputes with a long-term perspective. While immediate reactions to betrayal may tempt emotional responses, I found that calm analysis and reliance on objective evidence fostered stronger outcomes. Each step I took was measured and deliberate, focused on building a defensible case and ensuring client well-being above all else. Financially and professionally, this journey has reshaped my career trajectory. The practice's growth and increased profitability reflect not only regained market share, but also the enhanced quality of service and client satisfaction. Equity ownership provides both financial security and the incentive to continue innovating and expanding responsibly. I enjoy a more balanced schedule as well, allowing dedicated time for mentorship and professional development, luxuries that were scarce amid the constant crises at my previous firm. Importantly, the case stands as a testament to the power of legal and ethical frameworks to dismantle nepotistic arrogance. By adhering strictly to contractual obligations, fiduciary duties, and regulatory compliance, I was able to hold a powerful firm accountable and rebuild my career on a foundation of trust and integrity. This outcome underscores that justice in professional disputes is attainable not through confrontation, but through mastery of the systems we operate within. As I look ahead, I remain vigilant and committed to upholding these principles. The legal landscape will always present challenges, but with thorough preparation, clear documentation, and strategic resolve, I am confident in navigating future complexities. My experience has not only strengthened my practice, but also deepened my conviction that principled professionalism is the most effective path to sustained success in the corporate legal arena.